Hello and welcome, everyone. My name is Norani Lijon, and I'm Director of the Information Law and Policy Centre, one of the academic centres based at the University of London's Institute of Advanced Legal Studies. Thanks so much for taking the time to be with us for our second seminar of the Centre's series on AI and the Humanities, Transforming Society. These seminars explore the societal impacts of AI-based technologies and systems and the role of the humanities and social sciences in providing key insights and expert analysis to enable an open dialogue on these important and complex issues, both within and beyond academia, and very importantly, with the wider public. And it is my very great pleasure today to chair and to introduce our distinguished panel for a very timely and significant discussion on the impact of automated decision-making on society, human rights law, and particularly data protection. Our lead speaker today is Gabriela Sanfir Fortuna. Dr. Sanfir Fortuna is Vice President for Global Privacy for the Washington, D.C.-based Future Privacy Forum, where she coordinates the regional offices in Brussels, Tel Aviv, and Singapore. She leads the forum's work on global privacy developments, including de-identification, AI, mobility, ad tech, and education. She is also Associated Researcher for the LSTS Centre of Vrije University Brussels, a member of the reference panel of the Global Privacy Assembly, and a member of the Executive Committee of ACM's Fairness, Accountability and Transparency Conference. She has experience in working for the European Data Protection Supervisor's Office in Brussels, where she dealt with enforcement, litigation, and policy matters. She holds a PhD in law with a thesis on the rights of the data subject, very relevant to today's seminar. And she is the first Romanian author to publish a comprehensive volume on the rights of data subjects. She is also one of the co-authors of GDPR Commentary, published by Oxford University Press in 2020, and soon to be updated, as is this ever dynamic area of law. So Gabriela and Jezrek, you're very welcome today, and we're thrilled that you've joined us for this seminar. In terms of the format for this seminar, once both of our speakers have presented, we will open up the discussion to the digital floor. So we welcome any questions or comments you have for the panel in the chat box in the bottom of your screen. And we'll try to address as many questions and comments as possible in the remaining time. So now I'd like to thank both of our speakers and to thank you again for joining us here today. And I will invite Gabriela to begin today's seminar on Computer Says No, Fair and Accountable Decisions in an Automated World. Gabriela, the floor is yours.
Thank you so much, Nora, and thank you everyone for joining today. I will take up the first 25 minutes of the webinar, of the seminar, to present the results of a report that myself and my colleague Sebastião Barros-Val published in May for the Future of Privacy Forum, where we looked at a lot of cases under the GDPR on automated decision-making type of facts of the case. So I will be taking up that first part, and then we will hear from my co-panelists, and we will be able to take questions. I will try to share my screen, and I hope it will work to begin the presentation. Okay. So far, so good. 1 second. Do you see everything okay? Great. So I will start by laying out the map for today, what I plan on discussing, and I promise to keep an eye on the timing. First, I will introduce the case law report, speak a bit about how we came about it, a bit about its structure, and why it is a very useful tool, we believe, in studying these topics. Then I will look at why is the GDPR relevant to automated decision-making cases and algorithmic decision-making. I'm using there the GDPR, but I'm mainly thinking of data protection law generally. We will look at what are the GDPR legal issues most often dealt with in the case law that we studied. We will also look at how are the DPAs and courts solving these legal issues, and I'll lay out some of the conclusions. Now, if this will prove to be too long, don't worry, I will make the PowerPoint available to Nora in the center, and I'll just skip to conclusions. So no worries about that. Our report, as I was mentioning, was co-authored with Sebastião and myself. We worked at it for about a year and something. It was a really big endeavor. We almost felt like we published a thesis at the end of it. And it's freely available. I'm including there a link, and then I'll be happy to also share the link in the chat as we move forward. What the report does is that it outlines how national courts and data protection authorities in the EU, in the EEA, but also in the UK, have interpreted and applied relevant GDPR provisions on automated decision-making type of processing activities, of course, with a focus on Article 22 GDPR, and we'll see in a moment why. It also looks into, it looks into publicly available judicial and administrative decisions, but also into regulatory guidelines. Technically, we draw analysis from more than 70 cases. We are looking into 19 court rulings and more than 50 enforcement decisions from supervisory authorities, but also to individual opinions in specific cases issued by request from by authorities and into general guidance issued by DPAs. We limited the scope of what we are looking at in time up until April 2022. So nothing that was published afterwards will be captured in this analysis. And for some of the cases, we have used automated translation. Not most of them, because between the two of us, we cover a couple of languages, but we had to use automated translation for particular, I believe, the German language ones. Let's start with what type of cases did we find? You know, what are the automated decision-making situations around us that actually have people complain to a data protection authorities and have people go to court to exercise their rights? Well, we've seen situations where students and educational institutions were involved. Cases vary from the use of live facial recognition technologies to manage access on school premises and recording of attendance, to online proctoring, which boomed, as we all know, during the pandemic, and further to fully automated grading based on the individual profile of a student, but also on the profile of their school district. So we've seen this in the International Baccalaureate case as an example. We also see a cluster of cases that are generated by gig workers, and the way they are being distributed shifts throughout the mobile apps, the way they are distributed income, penalties through their respective platforms. A lot of cases on automated credit scoring, cases that look into the way in which governments distribute social benefits like unemployment and manage tax avoidance and potential fraud. Even the issuing of gun licenses we found as an automated decision-making case under the GDPR. It's a case from the Netherlands. Scraping publicly available data to build facial recognition technology, as we know the Clearview AI cases. Profiling of prospective clients by banks. One of the most recent cases that we looked at was an emotion recognition AI that was used by a bank for its client services. So as you can see, we are seeing situations of day-to-day life that touch literally upon all of our daily going about that are now subject to algorithmic decision-making, automated decision-making in a way or another. The report is structured in a peculiar way, and I want to give you a short guide on how to read it. So first, we're looking into the fundamentals of Article 22, and we break that article down. I'll speak about that article in a minute. But we also look a bit into the history of how Article 22 came to be in the GDPR, explain the conditions that trigger the prohibition in Article 22, we look at the exceptions that allow the prohibited practices in Article 1 to actually happen, and the safeguards that are required for the situations where exceptions apply. But as we were reading through cases, we also saw that the rest of the GDPR is very, very much relevant for this type of cases. So we're looking at some of the other provisions that courts and DPAs relied on when issuing their judgments and their decisions. Now, you will see that under each of these sections, we actually refer to a number of cases. So you will have one case, for example, the Uber case well, there are two Uber cases that were dealt with in the Netherlands by courts. You'll see that we will refer to it throughout the report under the sections that are relevant in the analysis of that case. And I think that's one point that makes the report interesting, because we're not just summarizing all of the cases and then at the very end come up with conclusions. We split the specific topics in each case, and then we distribute them on a topic-based sort of section. We spend a lot of time assessing the threshold that triggers the prohibition in Article 22 GDPR and how DPAs and courts have dealt with that. And then finally, in the last section of the case, in the last big section of the report, we are summarizing some cases in the three bigger clusters of cases in topics that we found. And those are workplace scenarios, facial recognition, and credit scoring. Now, as we go about analyzing all of these cases on all of these topics, we remain consistent in how we number the cases. So you will see throughout the report boxes that say case 6, for example, throughout the report. And you'll know that whenever you see case 6, it's about one of the specific cases. Now, why did we start looking into this? Why did we want to focus on this series of enforcement that we started to see happening almost under an avalanche since 2018, when the GDPR became applicable? So we started from the premise that data protection law, in fact, when it was sort of theorized, late 60s, early 70s, it actually had in mind, I would dare say, exactly algorithms, and this type of automated processing systems that we are seeing now, 50, 60 years later, actually happening in real life. So if we're looking at this seminal report from 73 from the United States, which is very surprising, I think you'll be very surprised reading this report and knowing it comes from the United States. It's called Records, Computers, and the Rights of Citizens report, and it's the report that theorized the fair information practice principles, which now are core to most of data protection laws around the world. You'll see that the reason why this report was given to as a task to this commission, special commission assembled under the US Department of Health, Education, and Welfare, was that there was a growing concern that automated personal data systems present a serious potential for harmful consequences, including infringement of basic liberties. So you will see that privacy itself was not the main concern when thinking of how can we deal with vast amounts of data in automated systems, right? From the very beginning, the concern was about how the automated systems that manage personal data affect basic liberties. And I think we are at a moment in time where we can really appreciate why these concerns were considered back then. We'll see here that I'm not going to read it out loud, But when you're looking at this report, you'll see that these were the basic concerns back then. We actually, it's actually a very good quote. Sorry about that. But in any case, around the same time, when we're looking to Europe, some very interesting things were happening as well. As we know, the United States didn't really adopt a comprehensive data protection law following the 73 report. It just went into adopting a narrow public agencies, a law covering only public agencies, the Privacy Act of 1974, and quite trimmed down from what the report was suggesting. At the same time, in Europe, the data protection laws in Western Europe were being adopted and discussed. And one of those was the data protection law in France. And perhaps you'd be surprised to find out that the French Data Protection Act of 1978, so back then, specifically prohibited solely automated decision-making in the context of judicial, administrative, or private decisions involving assessment of human behavior that would profile or define the personality of the individual. That was in Article 2, already from 78. And it also granted individuals a right to know and a right to challenge the information and the reasoning, which I think it's very similar to the logic involved in automated decision-making that we talk under the GDPR, used by automated processing affecting them. So we see the roots of what further developed through Article 15 in the Directive 95 and now through Article 22, already from the 70s. And then, of course, we have the GDPR now, and it has my favorite recital in the GDPR is recital 4, which at one point says that the processing of personal data should be designed to serve mankind. So if we pay attention to the recitals of the GDPR, we'll see that more often than not, we can trace a concern with how personal data is being processed, which is so broadly defined, and how it affects more than the privacy of the individual. So how it affects the vast majority of the rights of an individual, like freedom of speech, the right to private life, privacy, the right to life, the right to security, and so on. And some of them are specifically mentioned in recital 4. So we actually realized that the GDPR being built as it was being built, coming from that history from the 60s and the 70s, from the concern of policymakers and lawmakers on what is going to happen when automated systems, whatever these big computers are and whatever they will do with data that's input in them, how will that impact the lives, the rights, the civil liberties of people? Now, the GDPR, in my point of view, is the most modern expression of those concerns. And I think it's no coincidence that the GDPR is actually the legal authority under which all of those cases that I mentioned at the beginning are brought to the attention of courts and of course, data protection authorities. So why is the GDPR relevant? Well, it has a very broad definition of personal data. Of course, any information related to an identifier or identifiable individual. It has a very broad definition of processing. Any operation or set of operations performed on personal data, like collection, structuring, combination, making available, and so on. And this very broad scope, material scope, seems to bring training of models for machine learning, algorithmic decision-making, literally any form of automated decision-making that relies on personal data, as broadly defined as it is. I would even say, so even in mixed data sets, but I would even say also when it results in personal data, this all is brought under the scope of the GDPR, and it triggers the application of its rules, right? And this is why in all of these cases that I mentioned, the GDPR is relevant. All of them are GDPR cases. Then keep in mind that fairness, accountability, and transparency, which is one of the favorite things to talk about now in machine learning when we're looking at it from the legal side. Well, fairness, accountability, and transparency ad literam are the principles that are provided by the GDPR. In Article 5, I will correct my slide afterwards. Then we'll have a data protection impact assessment that needs to look and to assess the risks to the rights and freedoms of individuals when we are having complex processing of personal data. We have obligations now for data protection by design and by default that have a particular meaning. And all of this will be relevant in how these cases are assessed. Then, of course, the flagship article, the flagship provision in the GDPR that deals with this type of situations is Article 22. And Article 22, in paragraph 1, establishes what the EDPB has interpreted as a prohibition for certain automated decision-making to happen. So what it says in paragraph 1, it says that individuals have a right not to be subject to solely automated decision-making that produces legal or similarly significant effects on individuals. And throughout the report, this type of automated decision-making, so solely automated decision-making that produces legal or similarly significant effects, we refer to it as qualifying ADM. So it is qualifying ADM for this prohibition. However, the second paragraph says that this type of qualifying ADM can happen in three scenarios where it's necessary for the performance or to enter into a contract, where there is a legal obligation for the controller to perform this type of ADM, but the law will need to have some specific qualities for this obligation to be valid, and also on the explicit consent of the individual. So this type of qualifying ADM can happen if we have these three legal grounds, but also, as paragraph 3 indicates, when it happens, it cannot just, it's not like a sort of you gave an express consent and now qualifying ADM can be applied to you. It also has to embed at least these three safeguards. And I say at least because we'll see why the case law actually indicates that it's at least these three safeguards. The right to obtain human intervention on the part of the controller, the right to express the individual's point of view, and the right to contest the decision. So these three conditions as safeguards must be present whenever qualifying ADM happens under the three exceptions, the three legal grounds. So what are the legal issues that we most often encountered in case law? Of course, there is a lot of litigation on the concept of what constitutes solely automated decision making. What is it that's solely processing? What type of, how much involvement from a person is needed to reach that? There's also a lot of litigation about what amounts to a similarly significant effect to a legal one. The exceptions to the prohibition, so that express consent, a contract, legal obligation. We've also encountered some cases that challenge ADM, qualifying ADM based on those three exceptions. Of course, there's a lot of debate of what constitutes a good enough, suitable protective measure under the third paragraph. So one of those three types of safeguards that are required. What we were very, well, not surprised, but we actually found it in copious amounts, was that there is a lot of litigation, and there are a lot of cases about valid lawful grounds for processing and about general data protection principles like fairness for automated decision making that is not qualifying ADM. So it's automated decision-making that might not be solely ADM, or that might not even have a legal or significant effect. It's just automated decision-making and does not qualify under that first paragraph with the prohibition. But there are many cases that actually apply the GDPR in an effective manner also to that type of ADM on other grounds. And then, of course, there's a lot on transparency and access rights regarding ADM and profiling. Now, you will see that there are a number of examples in the report under each of these legal issues. So, for example, solely automated processing. There is guidelines from the EDPB that say that mere token gestures by humans are not enough to set the prohibition aside. So if you have a person that only rubber stamps a decision that software, some algorithm took, that's not going to make that particular algorithm or software outside of the scope of the prohibition. So it will still consider to be solely automated decision-making. So for example, we found this case in Portugal where a university deployed an online proctoring software that used biometric data and other types of data points to flag fraud during exams. What the Portuguese DPA did was that it decided that even a professor would ultimately exclude the exam taker from the exam. They found that the professor were just rubber stamping all of the decisions of the algorithm instead of actually being trained to use different criteria and so on to make an actual, let's say, substantial contribution to the decision of excluding that student from the exam. So we've seen in a number of cases that the courts and the DPAs have been looking at the organizational structure, who is taking a decision, who is intervening, let's say, in the automated processing there. It's looking at internal policies and procedures. They're looking at whether the staff was trained to sort of interact with how the algorithms made a decision or not. There are also very interesting data points on assessing legal or similarly significant effects. And this is about time for me to just run a bit through the presentation because I see I only have about 2 minutes left. I think what could be interesting is to talk a bit about how the general principles and lawful grounds of the GDPR outside of Article 22 apply to most of these cases. So what principles we've seen being applied were data minimization, accuracy, and fairness. And fair enough, we only saw perhaps 2 cases where the principle of fairness was core and center of the decision. So one of them was the decision of the Norwegian Data Protection Authority in the case on the International Baccalaureate, where the International Baccalaureate Organization during COVID decided to assign final grades to students based on an algorithmic processing type of decision. And the Norwegian DPA issued a preliminary decision, which unfortunately did not end up also being a final one because they sent the case over to the ICO in the UK due to a jurisdictional issue. But they used, they actually made a finding that the principle of fairness was not respected in this particular processing because some categories of students were discriminated against based on the school district that they were a part of and based on the average grades from the previous years in their schools that were taken into account for their individual performance and their automated grade. And then we also found the principle of fairness being very, very central to the decision of the Dutch Data Protection Authority in the Siri case. This is a decision from this year, and a decision that's a part of a longer, very, very impactful case that happened in the Netherlands, where the tax authority deployed an algorithm called Siri, or maybe the whole program was called Siri, that flagged potential fraud of the tax system. And the Data Protection Authority issued a fine to the tax authority for several reasons, but one key of those reasons was that they breached the fairness principle under the GDPR. Again, because the algorithm led to a discrimination in between categories of taxpayers, because it took into account as input data the situation of double citizenship, for example. And if someone had more than the Dutch citizenship, the algorithm counted that as that person having a higher risk of being a fraud, or committing fraud to the tax system. So that was one of the very interesting cases that we found. There is this emotion recognition AI system case in Hungary. There was literally a case that challenged an emotion recognition AI that a bank used to rank how angry clients that called to the client services were. And then based on that ranking, a person would prioritize whoever was the angriest. And that system was challenged. Article 22 was not at all part of the conversation because the Hungarian DPA decided that there was no decision being made. They decided that the ranking was not literally a decision. However, that emotion recognition AI, like the GDPR was applied to that entire situation, and the principle of lawfulness was found to be breached, transparency and purpose limitation, notice obligations, even data protection by design and by default. And the fine was 650,000 euros against that bank. I will end now. So some of the key conclusions that we found, and I highly encourage you to look through the report. It's dense, but it's not boring. Well, the GDPR covers automated decision-making processes and systems in a comprehensive manner beyond the specific safeguards that are offered by Article 22. And the legal analyses are becoming more and more complex, to be honest. The threshold for automated processing to classify as qualifying ADM is very high, but courts and DPAs have often found qualifying ADM present in specific situations. All automated decision-making that relies on personal data processing always require a GDPR lawful ground. So one of those lawful grounds in Article 6, and also must comply with the general principles, as I was saying, minimization, fairness, and so on, transparency. What was very interesting for us to find was that, for instance, where consent is relied on for automated decision-making as a lawful ground, a very key part of the assessment that the courts and DPAs do is how much information does the person who consents have access to, and the type of information. So we have a very interesting case from the High Court in Italy, where an entire algorithm was declared unlawful because the controller was not giving sufficient information about the logic involved in it, and how it works. And because it was relying on consent, the court decided that since consent is not properly informed for people to understand what's going on, then the entire thing was unlawful. Of course, transparency and data access are mandated for both qualifying and non-qualifying ADM, but more detailed information is needed indeed for qualifying ADM. And you'll see a couple of cases to that extent. So Sorry for going over time. I knew I would do it. But as you can see, I'm very passionate about the topic. And thank you so much for the opportunity to present the report and some of our results.
Thank you so much, Gabriella. And I just want to reassure everyone that it's a fascinating report. It is very comprehensive. It provides some very, very interesting findings on what is a very strangely structured right/prohibition within the general data protection regulation. And Gabriella touched on this earlier on, but I think what is so significant for anybody interested in this area, whether you're an academic, a legal practitioner, if you're interested in this field for any reason, if you're someone who's passionate about information, digital rights, digital literacy, and so on, is that the report very helpfully provides a really important source of reference for a very significant number of judgments across Europe, where judges have very helpfully, through the legal challenges that have been brought by a number of individuals and civil society bodies, they have given teeth to the requirements and the safeguards within Article 22. And the report very helpfully consolidates so much of this very rich and relevant case law that has put flesh. I'm using all the metaphors right now. That's putting flesh on the bones of Article 22 of the GDPR, which is very important because all of these judgments, as the report shows, they are providing a map for controllers and processors as to how Article 22 of the GDPR, as Gabriella mentions, how it intersects with all of the other requirements within the GDPR, the principles, the basis for lawful processing, for instance, and all the different requirements that are needed in order for Article 22 to apply in practice, and the specific requirements that need to be met in context-specific situations. And as Gabrielle was explaining, I mean, this technology is something that is widespread now, used in schools, by banks, financial institutions. I mean, any sector aspect of life that you can think of, automated decision making is playing an increasingly significant role. So I could go on myself. I'm very enthusiastic to discuss this more, and I have all the questions for Gabriella, but I will stop there and thank Gabriella for such a fantastic and insightful presentation, which is very comprehensive in terms of the time that she had. And I'm very excited to introduce our discussant and second speaker today, Jedrzej Niklas. He is a research associate at the Data Justice Lab at Cardiff University and an upcoming research fellow at the Polish Academy of Science. His research focuses on the governance of data technologies and their social justice implications. His recent project, Data Forests, explores the use of digital technologies for natural resources management and sustainability, another very important topic in data governance and future. Jedrzej has a PhD in international law from the University of Warsaw, and previously he was a postdoctoral researcher at the University of Leeds and the London School of Economics, where he analysed problems concerning algorithmic discrimination. So Jedrzej brings, a very rich source of insights now for rights that, as Gabrielle mentioned before, go beyond just privacy and the protection to private life, but extend to issues such as due process, inequality, and non-discrimination. Jedrzej, the floor is yours. You're very welcome.
Thank you very much. I will not have any slides to share. My intervention will be like around 10, 12 minutes. Thank you, Gabriela, for your presentation. That's a really amazing report. I was going through it yesterday. It is quite dense, but it's also like so fascinating for me that we already have such an interesting set of court cases and decisions. And I remember we mentioned this before the event started. We met a few years ago with Nora, and we were like talking about this algorithmic decision makings. And 5 years ago, 7 years ago, there was almost nothing. And suddenly we have all those 70 different cases, also with very often sophisticated interpretation, which you make an excellent point in the report. I'm really encouraging everybody to have a look at it. I will have like 3 different points in my intervention, maybe 4. And I wanted to start, I will just open my notes, to this more kind of, I think you definitely mentioned this historical evolution, I would say, because in the 1960s, 70s, and this is also like I've been doing small historical research on automatization as well. That was at the core, like the automatization and the fear and anxieties about computers that will take the decision making from the humans. That was the important and the most important element in the political discussions that led to the data protection regimes or any kind of legal regimes that were related to computers. And it was, in not only in the US or France, it was in Sweden, it was also in communist countries at that time, that were the countries were at this moment experimenting with cybernetic system, with automation system, also in the context of modernizing welfare state that was more complex and needed more sophisticated processes and systems to calculate, for example, pensions or benefits. And those anxieties related to computerization led to this kind of first wave of laws related to and policies related to data. And I think we forgot about this. What you exactly mentioned, Gabriela, in the first minutes of your presentations, because then in around late 80s, 1990s, all about data protection was somehow related so strictly with privacy that we almost forget that those kind of initial discussion were rather about something not different, but also there was something more additional and different kind of anxieties. And I think maybe that was also related, and I think that was especially related to those kind of summers and winters of AI and automatization, because at the 1970s, there were a lot of dreams of automated countries, of automated bureaucracies, but 1980s, 1990s, those dreams were not delivered, and suddenly we go to different kind of topics. And now what we do is we have those systems, and this is especially seen in your report, in almost every single aspect of our life, from welfare, from jobs, from education, and all those different areas. Now we can see that automation and automated decision-making systems are interfering very, very much in our lives. And we can see it that they affect equality, that they are a really big problem with transparency, with all of different kinds related to power structures, in the particular spheres, be it university or social protector systems. And I find it really interesting that we are now discussing those things, and especially from this kind of human rights perspective, we can see that discussion evolved from anxieties around privacy in the 1990s, early 2000, and now going back to those kind of relations and things, anxieties related to discrimination, equality, social rights, labor laws. I find it really interesting how those things evolve. And it's not that it was not part of the discussion, because, Oscar Gandhi, for example, really amazing media scholar, was saying in 1990 that what is about those information systems is not about that they are monitor us or surveil. It's that because they are sorting, profiling, and making decisions that are leading to really important consequences in our life. So I find it really interesting that we are now talking about slightly different issues, and we can clearly see the evolution in last years. Probably it is also related to this kind of hype around AI, also in relations to probably AI policy and AI acts in different countries, and also in the EU. But I also want to do a more general point from my perspective, from the person that is working on this kind of social justice, data justice issues, that while we think about automation, it is also not only how the system works or they don't work, on what kind of problems of transparency they create, but also that that the reasons why they are introduced, they are very often related to very political and economic structures, especially in my area that was for a longer time now focused on technologies in welfare state and welfare administration. It was most often related to the austerity policies, to neoliberal reforms, cutting spending. And while I see the GDPR potential in addressing, for example, issues, just as is clear in your report, Gabriel, about transparency, those big political issues, I think there's still like something really, really, really important, and sometimes we are not saying it strongly enough, that this is, those systems are political system at the end. I have like two, I think it will be kind of questions or ideas strictly related to the report, and I was thinking what you, Gabriela, think about this. The first one is about this complexity of interpretation, especially if you think about organizational structures, because I think there's like almost like some kind of expansive scrutiny now. It was seen in few of the cases that you mentioned in the report, that especially when you think about this solely automated decision character, the scrutiny around that is evolving, not only looking at the system itself, but the chain of command, I would say, the training of the people who are using it, the rubber stamping. But it's like it's a really complex way of thinking about interactions between human organizations, technologies, almost like looking at this whole assemblage. It's fascinating. A few years ago, in 2015, I was working on the Polish case of the profiling system used in job centers when I was working at one of the Polish NGOs called Panoptykon Foundation. And for years, we were like trying to understand how those job centers are using the system. And it was like really hard, not even for us, but also for them to understand if the system is automated or not, and when it is automated or not. And I think that is really something, at the practical grounds, it's like a huge challenge. And I'm wondering where you can see some kind of challenges for interpretation here and for the intervention. The second thing is also, and I find this is really fascinating, especially in relations to, for example, Siri case, but also the cases that you you didn't mention in the presentation, but that they are really interesting in the report. The Italian cases about gig workers, but I think also German probably, or Austrian. I don't remember exact countries, but definitely the Italian. When there is like this kind of intersection between GDPR and labor laws, for example, or in case of the social security laws, and this is creating like some kind of interpretation, and especially on the side of data protection authorities, when they try to now intervene, they are expanding their competences, I think, to some extent. They are making points about labor law. And for example, in the Italian case, it was about if the gig workers are workers in some degree. This is also related to this, what you mentioned in context of fairness in this Norwegian case, especially when data protection authorities will now not only many, or some of them maybe, not only think about this data protection as this kind of procedural law or procedural issue, but something that, for example, not only thinking about data minimization, but also the categories of data and what are fair categories or not. And I think that's raising huge questions. Do they have competences, powers, educations to do that? I think that's really fascinating. And in the conversation and interviews I did, for example, in Polish data protection authorities, they don't want to do that. The representatives of the DPA, they will say, oh, we don't feel that we have enough competence in, for example, in relation to discrimination. Like, we are very good in, go into this more procedural aspect, but we don't want to make the decisions if the data are or decisions made or based on this particular data points are fair or not. This is something that we want to left to somebody else, but also who that will be. I think that's another question. So I think that's creating some kind of challenges and also opportunities. Maybe GDPR and those kind of data protection legal systems should be now like this kind of human rights code for in the context of computerization. Why not? But on the other hand, why not to, for example, expand labor law, especially in the context of gig workers? I think this is somehow happening, especially with this new directive on gig workers in the EU, for example. So maybe it's happening simultaneously, but I think there are a lot of intersections here that are still not addressed. And I find some challenges and some opportunities as well. And I was wondering, how do you feel about those challenges and this kind of expansive role of data protection? This going to this kind of different areas that are quite foreign for data protection practitioners, I guess. And I think I will start and I will finish here with this intervention with those two questions. If you would like to answer somehow, Gabriela, thank you.
Those are absolutely fantastic observations. Thank you so much for that. And they say in very, very well put words what also I've been thinking about while collecting the original cases, reading through the summaries, trying to analyze and find this common criteria that judges and DPAs were looking at. And I think you are right in everything that you said. I would even note more complexities there, because at one point I was surprised to find one of the criteria being used in indeed one of the Italian cases, I believe the Fudinho case, of what constitutes a similarly significant effect, similar to a legal effect on the individual, that's based on the algorithmic decision making. One assessment was done about whether that decision affected choices or conduct of data subjects, right, of people. So not only that we have this extraordinary complexity of systems that you mentioned with the assemblage of organizational structures, how organizational systems, who reporting structures, training, and so forth and so on. But then there also seems to be like an introspection within the individual, and how much did the fact that they will be having like a smaller fee for the delivery within this 2 hours, will that affect the conduct and the emotions of the choices and the conduct of the individual? And it's very unlikely that data protection authorities are well equipped right now to do those types of assessments. However, if we're looking at, when I started to look into cases in this field about 10 years ago, everything was very dry. All of the assessments were quite dry, quite short, quite procedural, just as you said. But I think that as the field evolves, it experienced an exponential sort of development towards this very complex assessment. And I think this is a good thing, but at the same time, it raises the challenges that you just highlighted. Who is ready to make this assessment? What type of training can literally an administrative body of a state need to be able to do this type of assessment? Now, I would also add to the mix that it's not only DPAs that are knee-deep into this, but it's also courts. And I think we should also talk about the capacity of the judiciary to engage in this type of assessments and to be very familiarized with the computer systems, with data flows, and with the instruments they have here, like data protection law. And I think this is another topic, and you'll see in the report that there's a lot of back and forth in between data protection authorities and courts. Yeah, so I would leave it at that as my reply, in just wondering if there are questions that we can also take, Nora, from the audience.
Jedrzej, if I could ask you to share any final thoughts that you have, because we are over time, and I would like to apologize for everyone for me getting carried away with my enthusiasm and with these fantastic presentations and interventions that we have gone over time. But I would graciously request that our two speakers give us their final thoughts in just a couple of minutes each, and then I will bring this fantastic session to a close. Jedrzej?
Just also to address a little bit to your question with, and maybe play a little bit of devil's advocate, maybe, you know, like the role of executive, especially here, and especially when you think about the reality of enforcement. I know ICO is like very different and very big comparing to other enforcement agencies in the EU. Well, the executive can be more fast than independent, not well-financed authorities. And from some perspective of efficiency and speed of protection, this might be sometimes even better. But of course, not in all questions. I would really doubt if, for example, in the context of policing and in all those kind of law enforcement issues, that would be a case that the protection of rights would be the priority. But going to some kind of more broader remarks, and I think I will just go back to my first thought. It is such an amazing thing to see this kind of speedy evolution of cases, of sophisticated interpretations, and it's a really fascinating field, and I'm still fascinated and enthusiastic about it. So it was very, very nice to see the report, Gabriela, and hear your thoughts and your presentation. It was a pleasure. Thank you very much.
Well, it was an absolute pleasure for me too. I felt like we had a conversation among friends, which was great. And thank you so much for all of your thoughts and reactions and for the discussion. I really missed this type of engaged, substantial conversation. Thank you.
Well, it's nothing left for me to say except for really begrudgingly have to thank these speakers for what was a really fascinating and insightful analysis into what is such an evolving and hugely significant area for everyone, whether you're interested in data protection or human rights law or not. The impact of automated decision making in every sector of life has and does affect everyone. And I think the harms and the benefits that come from the use of those systems, and certainly their ongoing expansion, is something that we all have to be mindful of going forward. And from that perspective, and for anybody interested in this, furthermore, from a legal standpoint, I would highly recommend that you do check, if you haven't already, looked at Gabriela's co-authored report for the Future Privacy Forum. It gives such a rich set of insights as to how issues resulting from automated decision-making and some of the unfair problems that have arisen concerning unfair and unlawful discrimination and the interference with other rights have arisen in particular sectors. And it is a very worthwhile read that I really can't commend to you enough. And on this note, I would like to thank both of our speakers today, Jedrzej for being such a fantastic discussant and for being a wonderful devil's advocate. I wish we had more hours with us so I could counter some of the very provocative but very interesting points that he's made. And I'd also like to thank, of course, our lead speaker, Gabriela, for giving us a fantastic overview of this comprehensive report. And I will leave it to you both to have a good evening. And I really look forward to seeing you both soon, I hope in person. And a big thanks to our audience as well for some really fantastic questions and insights and comments. So wishing everybody a good evening. Thank you so much. Bye-bye.